folks have a seat. We're still on the record. Ms. Lewis, I apologize for interrupting you. I think this would just be an easier way to have the conversation that we were having. Go ahead, complete your thought for me. Regarding jail calls.
Well, there's hearsay in this call also from the other party,
That will be true with every call. And so we'll need to come up with an instruction for the jury about how they are to treat the other side of each of these calls.
All right. Well, I guess our objection is that these calls could and should be introduced through an actual witness. Playing them randomly, I think is confusing for the jury.
May we stay focused on this particular call for a moment to tease out your position on that? So this is 2-95.
I'd like to look at that again, but I also think that
Hold on, I wasn't finished with my question. My apologies. This is 2-95.
Yes, sir.
What was the number again?
295. 295D.
Okay, so 2-95D, as I understand it, the state is seeking to play now because it relates to Ms. Richins having contacted Ms. Bramwell. Is that fairly stated?
Yes, Your Honor.
Okay. And so I think, as I understand the state's position, playing it at any other time than directly following Ms. Bramwell's testimony would be confusing. That's what I'm gathering from the state's position.
Correct, Your Honor.
Okay. So take it from there, Ms.
I'd like to I haven't looked at this call in a couple of days, so I'd like to look at it, but I also think by introducing these things without a witness on the stand is a violation of our Sixth Amendment right to cross-examine. When we introduce these randomly, we can't cross-examine anyone about these calls.
Well, are you talking about foundation or content?
I'm sorry, what was that?
Are you talking about cross-examining regarding foundation or content?
Content.
Well, the content, the part that's being admitted for the truth, is your own client's statements. So the confrontation problem doesn't exist there. And if we instruct the jury not to consider the other half of the conversation for the truth, there's no confrontation issue there either.
Well, if they were to call the witness, who is the other half of the conversation, and introduce the call through the witness, then we would have an opportunity to cross-examine regarding the phone call.
But not if the other half of the call isn't being admitted as substantive evidence. They're not admitting the other half of the conversation as substantive evidence of anything. And moreover, I'm going to be instructing the jury that they can't consider the other half of the call as substantive evidence. I think I have to under the hearsay rule.
Your Honor, I still believe that we need to have the call through a witness. If they were to call the person who testified, the person who's on the other half of the call, then we would have the right to cross-examine them about the content of the call. And we don't know what that evidence would be. There may be more to this call or more context to this call that the individual can explain. By just randomly playing calls, we don't have any opportunity to cross-examine anyone or do anything with these calls. And then the jury just takes these calls as without an opportunity for us to put in any explanation about these.
Yeah, I feel like you're intentionally ignoring the fact that I'll be instructing the jury to not consider the other half of the call. But I understand your position, and you have to acknowledge that you have the power to subpoena the people on the other side of the call if you want to. But let's stay focused on the half that the jury would be allowed to consider from each of these calls. And that's your client's own statement.